You know that sometimes when some lawyers do some things, I'm tempted to want to meet them and ask them, what law school did you go to? Because it can't be the law school that I went to. We weren't so taught. I have here with me 2 letters, and they just feel from, the, letters that we get at our mediation center from lawyers who are sometimes so angry that they are even committing grammatical errors in their own letters, unnecessarily verbose, and very, very discourteous sometimes. So I'm just going to read to you a few paragraphs of the 2 letters so that you understand what I'm talking about. Here, the lawyer says, this one was written to me. They addressed it to me. So, to our client's surprise and chagrin, the mediation conducted that day was tainted with intimidation and psychological harassment of our client, which should be cast, grammatical error, an expression of disbelief and doubt in his mind. And it was apparently clear that there was should be bias, but grammatical errors. And favoritism, which can only be an outcome of a prearranged decision to cow our client from making his counterclaims or counter allegations against the complainant. It became apparent that there was no mediation but an intimidation. The mediator became the chief spokesperson for the complainant, while at the same time discountenancing, but grammatical errors. Maybe they write these things in such haste, like, oh, let me attack them. Discountenance and refused all efforts by our clients to lay out its facts and demands. How do you refer to your own client as it? It, a living thing, a living being. It, a man. It, or a woman. Let me not disclose the sex. It, for crying out loud. Calm down. To lay out its facts and demands. This is a gross breach of our client's right to fair hearing as enshrined in the Constitution of the Federal Republic of Nigeria, 1999, as amended. I'll leave a link to my video on fair hearing. It's not related, but I'll just leave a link to that video in the description box. The other paragraph I want to refer to, it is highly noted that on 2 occasions when appearance was made before your panel, one is convinced that justice and fairness cannot be achieved, as the one-man panel sided with the complainant, who apparently had acted contrary to custom and even common sense. Of course, our client has legal rights in this matter to decide, and he has decided that he no longer has confidence in the mediation process, and thereby choose to approach the family court, and thereby choose to approach the courts, and so on and so on and so on. It's so tiring. But for this 3-paged letter, this 3-paged irate letter full of abuse and insult and castigation of mediators and the mediation panel, the mediation center, all these people wanted to say to us was, we are no longer interested in mediation. We would go to courts. It's funny because the way this matter ended, we had even advised the parties to go to courts or seek other legal means of settlement because they could not even agree. But this lawyer comes and starts to castigate us that we were speaking for one party, we were this, we were that, they have no confidence in us. They even defined the meaning of mediation to the mediation center and to mediators. Can you imagine? And then they fell back to the solution that we gave the parties. We are going to court. Like we told you, if you cannot agree, go to court. And now you're coming back to tell us we have gone to court. We did not even adjourn for another date. Like we didn't tell you come back on so and so date. That should tell anyone that mediation has broken down and we are no longer interested or sensed of this matter. But what did you do? I don't know what the import of this letter is or was. But you wrote a letter, a 3-page letter to us just to insult, abuse and castigate us and to tell us that you have now gone to court. It's unnecessary. Lawyers, whether you're doing ADR or litigation, law practice is not the Third World War. You do not have to fight your colleagues. It's off-putting and very, very, embarrassing for lawyers, and I feel like some people don't even see it like this. Sometimes the judge has to caution lawyers in my presence in court and say to them that, oh, please don't take these things personal. You're only doing what you're being paid to do. Clients come and clients go, but lawyers will remain in the profession. So do not let it descend into fight. You don't have to. There's camaraderie at the bar, fine. Where do you throw that camaraderie to when you defend your clients or when you accompany them for ADR? The thing that shocks me the most is that when you accompany your clients for ADR, it is assumed that you believe in peaceful and amicable settlement. But most times as a mediator, what I find is that the lawyers that come with their clients come to complicate matters. I don't know, maybe they are scared that, oh, if we settle too easily, this man or this woman will not pay me. No, you're entitled to your remuneration even for ADR conducted or facilitated. And particularly for mediation, you should understand that mediators do not make decisions. I'm going to have to make a whole video on mediation and what it entails. It's high time I did that, by the way, on the channel, and I'm going to do it. But mediators, and I always restate this, almost every time I sit on a mediation session, we are not making decisions for you. We are only facilitating amicable settlement. So you tell us what you have come for, the other party will tell us what they have come for, and you tell us what you want, they tell us what they want, and we try to help you, dialogue until you can reach an agreement that is practicable and fair to both of you, and then we do an MOU. That's it. Nobody's forcing anyone's hands, and no one can speak for the other. This particular mediation that this 3-page letter was written about, the complainant, that is the party that complained, was the person that decided that she was no longer interested in the mediation. So how do you, as a respondent's lawyer, come and attack us with this kind of letter, with such, insulting language? I've left out some things because, time will not permit, and it's absolutely not necessary. So I don't know, maybe lawyers in this jurisdiction, or is it just everywhere? I'm shocked each time that lawyers descend into this kind of, belittling and, very, very embarrassing, attitude and character in court, in mediation sessions, anywhere. The other lawyer is not your enemy. The case is the challenge that both of you need to tackle with all sense of civility. Where is your civility, Nigerian lawyers? Where is your civility? It's off-putting, honestly, and off-putting as well. This other letter too, they wrote to tell us that, oh, we won't be coming. This one, we had not even mediated upon it, but they were telling us that we won't even be coming for this mediation because our client is not interested in amicable settlement. They say that, oh, I have my client's expressed permission, another grammatical error. Why is it that most of these people that write to us angrily always have misspellings and errors in their work? You guys should get a proofreader in your law firms, please. So it says that my client's expressed permission. What's expressed permission? Express permission, that's what it is. And this lawyer is writing in first person singular. Is that how we write letters as lawyers? Do we not write in third person plural? Do we not say we? We are solicitors too. We are solicitors too. We are writing on behalf of. Why is this person saying I? Is this a sign of anger, or is it that lawyers that tend to write such angry letters are just not, up to par in other areas? I don't know. It now says that my client is not who the complainant says she is, and thus she has no right to demand what she's demanding of my client. Okay, so he said, I decided not to reply the attached letter because my client and I want to keep our gunpowder. It's gunpowder, not gunpowder. Another mistake now, not an error. I'm presuming that's a mistake. Gunpowder dry until when it will be needed. They wrote needed, double D instead of double E. But I cannot see a letter from your respected office, and particularly a letter signed by my learned colleague, insert name of learned colleague, and not to respond to it. Now the mediation center writes letters to invite people, and any of our officers can sign. But now you saw the name and decided that, oh, I know this officer, and you are responding to an official letter in personal capacity and addressing, the officer in personal terms. It's not done. Address our office. That's how it's done. So you are saying that your client will not come. So he now says, please tell the complainant to seek redress in court with Please tell the complainant to seek redress in the courtroom with requisite jurisdiction, as my client is not prepared for any amicable settlement with the complainant and may not be available. This is the most important paragraph in this letter. You could have written a letter and said, oh, regarding this invitation that we received from your office, our client is not open to amicable settlement and will not be coming. Simple. Why did you have to make it 2 pages? 2 pages. Deforestation at its best. I wonder how many trees went into this and this. How many trees? How many trees? And we're shouting, ozone layer depletion every day. Global warming. You're contributing to it because of your anger and your inability to be civil and, to let things go. If you're pulling out of a mediation session, or if you're not interested, you can say that in 1 or 2 paragraphs, very courteously and very respectfully to your colleague on the other side. Because even though we are an official apparatus, we are human beings as well. So please, lawyers do not have to fight always. I was in court the other day, and the prosecution did not have their witnesses, because they had assumed that the defendant would come and move an application, and they had filed their counter, and they had assumed that once they moved that would be the business of the day, especially because they had other matters in court. It was a long court list day, so it was towards the afternoon, and so this defendant rises and starts to say that, oh, I have the complainant in this courtroom when the prosecution is not ready to prosecute this matter. They don't even know their own witnesses. I have their witnesses here in this courtroom. Their witnesses are here. They don't even know their witnesses. Can you imagine? Just to score a point against the prosecution. But in a very interesting turn of events, the prosecution rose up and thanked him for bringing their witnesses, and then they called the witness into the box to open the case. And this lawyer had come to withdraw the case. Like, you wanted to withdraw, and you wanted to actually cite that the prosecution has been postponing and adjourning, and that the complainant has even written a letter saying they are not even interested in the matter, and you have a copy of that letter. You could have just moved on with that business and said it in such a courteous and civil way that the court will hear you, or even liaise with the prosecution before they call the case, and then you come in the open court, and both of you will present your matters as earlier discussed, and the case will be resolved. But what did you do? You rose up trying to gloat over the prosecution, telling them you have their witnesses in court, that they don't even know their own witnesses, and their witness had written a letter which you have saying that they are not even interested in the matter. Well, the prosecution called the witness into the dock and opened that matter. And now a matter that might have been successfully withdrawn has been opened and goes to trial, just because one lawyer wanted to gloat over the other. Just because one lawyer wanted to get back at the other. It's not necessary. Please, law practice is not the Third World War. Please, lawyers, please, face the case, not the person. Stop all these ad hominems. Stop attacking your colleague at every given opportunity, even in ADR sessions. It's not the Third World War, and honestly, it's not that deep. I'll see you in my next video. Toodles.